Driving While Intoxicated attorney Andrew M. Stengel. In New York, drunk driving is known as driving while intoxicated, or called DWI for short. New York law calls the crime DWI, but the name varies from state to state. So you may have heard the term DUI, or driving under the influence, or OUI, or operating under the influence, and OWI, or operating while intoxicated. In New York, there are several different charges associated with driving while intoxicated, whether by alcohol or drugs. Chemical test failure and per se intoxication. The first and most common way that a driver is charged with DWI is with a blood alcohol content, BAC, of 0.08% or higher. This is referred to as per se DWI. While 0.08% is often referred to as the legal limit is actually below 0.08%. With a BAC of 0.08% and above, the driver is violating the law for DWI. BAC is commonly measured by a breathalyzer and less often by a blood test. However, there are a number of ways to challenge a BAC result at trial. Failing a breathalyzer by testing at 0.08% BAC or above does not necessarily mean a conviction. DWI without a chemical test result, common law intoxication. When a driver refuses the breathalyzer test, a prosecutor may pursue a charge of common law intoxication. It is illegal in the state of New York to operate a motor vehicle while in an intoxicated condition. Obviously, in an intoxicated condition, it's not nearly as clear as a BAC of 0.08% or greater. So, a driver may be convicted of driving while intoxicated even without the result of a breathalyzer or blood test. The kinds of evidence in DWI cases without a breathalyzer result typically include the subjective results of coordination tests, which are videotaped in New York City, the subjective results of standardized field sobriety tests, which are more often performed by police outside of New York City, the observations of driver by the police officer who made the arrest, which often include watery and/or bloodshot eyes, slurred speech, unsteadiness on one's feet, and/or odor of alcohol. In New York, DWI penalties for the misdemeanor crime include up to 1 year in jail, a fine of up to $1,000, a 6-month driver's license revocation, up to 3 years probation. Additional consequences associated with a misdemeanor DWI conviction include a program to address intoxicated driving, a court surcharge of $395, a driver responsibility assessment of $250 per year for 3 years, the required installation of an ignition interlock device on any car owned or operated by the person who was convicted for at least 6 months. Other consequences associated of a DWI conviction. In addition, a driving while intoxicated conviction, which results in a criminal record, will have consequences beyond the penalties imposed by law. DWAI in New York. Driving while ability impaired, also called DWAI, is the least serious DWI-related charge in New York. DWAI is not a crime, but rather a traffic infraction and does not give a person a criminal record. DWAI is defined as operating a motor vehicle while the person's ability to operate such a motor vehicle is impaired by the consumption of alcohol. DWAI arrests occur when the driver's chemical test result shows a BAC of greater than 0.05% but less than 0.08%. The maximum possible penalty for a first DWAI conviction is a fine of up to $500, a 90-day driver's license suspension, up to 15 days in jail. In addition, the driver can expect a $255 court surcharge, a $250 per year driver responsibility assessment for 3 years. The consequences are more severe under special circumstances, such as if a driver is under the age of 21 or the driver holds a commercial driver's license. Aggravated DWI in New York. Aggravated DWI is charged when a person has a BAC of at least 0.18%. The additional penalties for an aggravated DWI conviction include a fine of $1,000 to $2,500, a minimum 1-year driver's license suspension with the possibility of a suspension for a second year, required installation of an ignition interlock device on any car owned or operated by the person who was convicted for at least 6 months. Felony DWI, New York. Driving with an extremely high BAC isn't by itself a felony in New York. Felony DWI charges arise if the driver has a prior DWI conviction in any state within the previous 10 years, or there is a passenger in the car who is 15 years old or younger. The penalties for conviction of felony DWI in New York include up to 4 years in state prison, a fine of between $1,000 and $5,000, a court surcharge of $250, a driver's responsibility assessment of $250 per year for 3 years, probation for up to 5 years, license revocation for 1 year, which may be extended by the court, mandated use of an ignition interlock device, a program to address intoxicated driving.
As a former prosecutor and current criminal defense attorney in New York, Andrew Stengel has successfully handled hundreds of alleged DWI cases, whether a driver agreed to a breathalyzer test or refused a breath test. Visit the website of Andrew Stengel for more information, STENGELLAW.com, or send an email to info@stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.